Hello, this is Module 3 of Lecture 2, still dealing with effective communication, and this module is going to be looking at the models that we use as lawyers to assist with the difficulties that clients come and see us about, basically trying to solve their problems. So what actually is a problem-solving process? Well, I like slide 3, which talks about problem solving is to find the answer to a question or a difficulty in need of solution. And as lawyers, that's what we're all about. We have clients that come to see us because they have, whether it's a personal issue dealing with an employment law matter, maybe a family law matter, criminal matter, or they might be involved in a transactional matter. We might be dealing with people from corporations or businesses that have an issue relating to their workplace practices or the general running of their business. So inevitably there is some issue that needs the assistance of a lawyer. So how do we go about that? How do we come out of law school and be able to identify what the problem is and actually how we go about helping the client to achieve an outcome? There's a number of models, and this lecture is talking about a number of them. It might be that you consider the traditional legal approach that we have as lawyers, and that is that we start analysing issues on a number of levels. So when someone is talking to us, we start thinking immediately, well, what actually is this area of law? Is it a statutory matter that I need to be, have my head around? Is it a contract matter? Is it a criminal matter? So the first sort of point of thinking about it is to start identifying the framework where you're going to then start funneling down into research. So breaking that down, is it a contract matter? Is it a tortious matter? Is it a criminal matter? Is it relating to some form of statute? And of course, then we start thinking, well, what's relevant? What is the material that I need to know about this? What's the best way and approach that I can start to explore to assist the client's outcome? Because it really is a process to achieve the client's needs. And structure is the best way that we can approach a problem. Particularly when you come out of law school, one of the most daunting things is, well, what is this problem even about? I remember very clearly sitting just looking at pieces of paper thinking, well, can't even get my head around the particular area of law that I should be going down. And that's often that first reaction of, what is this? Is it something that I've considered, or is it something that I did as an elective at law school, or is it something that's involving an area of law that I have absolutely no knowledge about? So the process is, in that interview with clients, obtaining all the facts, and this, again, big flashing lights, alarm bells. For your client interview, it is not about a test of your legal knowledge. The client interview is all about listening and obtaining facts from the client to assist the next stage being to engage in that problem-solving process to then ultimately being able to advise the client and assist them with the outcome. So I said there are a number of models, and I'm sure those of you who are listening through your law degree will have come in contact with a couple of them, maybe IRAC or maybe even MIRAT, that some of you may be aware of. I remember when I first came to UTS, and there was a subject that no longer exists because of the changing competencies by the LPAB. And we did a proof-making model, and I was thinking to myself, what is a proof-making model? I mean, I sort of couldn't get my head around what they were talking about. And then as I sat down and I worked through what the proof-making model, I thought, this is what I do on every single matter that I have. And so it's just identifying the process that you apply in a practical scenario to achieve an outcome for the client. So the IRAC IRAC is a simple model, but interestingly enough, there is a presumption that you know enough about the facts in the area of the law to identify a specific issue, and that is one of the criticisms of this model. But this is something that might work for you. You might think, oh well, no, I can actually use this to good application. Then, of course, there's HIRAC, which is a variation of that, where you might be able to identify headings and then be able to work through on that perspective. One that's very popular is MIRAT, which John Wade from Bond University, who is heavily involved in the ADR and the negotiation scene, that it's a very interesting one because he's looking at identifying material or relevant facts and then going through the issues of law, the research, the arguments for and against, and then to reach and justify a tentative conclusion. So again, something that you might want to explore further and consider. And then there's the SCARP model, and this might be one that would be useful if you're having difficulties to even start identifying issues. What is actually the subject matter? I always like to adopt the approach that just pull back. Sometimes we're a bit stressed because we don't know where we should be going. Take a step back. Even ask simple questions. Is it a criminal matter? Now, if it's not a criminal matter, it's going to be a civil matter. And you're going to know pretty quickly if it's a criminal matter or not. So if you discount criminal and you're into civil, then you say, okay, back to basics. If it's a civil matter, is it a contractual matter or is it a matter that's involving a tortious action? So again, simply break it down and just start thinking about it. Now, if it's a contract matter, you then have to go through and get that grey matter that you remember from your contract days about, all right, what is needed to establish a contract? Is there an offer? Is there acceptance? Is there consideration? Is there performance of the contract? Go through all those essential elements that you know from those days of learning in the law degree. And then in a tortious matter, it might be, well, is it a common law action, or is in fact there a statute that I need to be mindful of, such as the Civil Liability Act, for example, and of course the same is true for contractual matters. So go back to basics and then be able to start unpacking it in more detail. And it really is all about moving through facts issues onto the rules and then being able to do the research. The worst thing you can do is start just researching broad areas without having some degree of purpose or structure. That takes a lot of time and it's inefficient. So go through that first initial stages of just unpacking what is it. Let me identify the area. And then you will, when you research, go down lots of rabbit holes and you'll go down and you'll think, yep, this sounds great. I'll go down this area and I'll research it, and you get to a dead end. You think, okay, I'll have to go down and look for somewhere else in another area. So it is all about exploring and unearthing what is relevant to the particular issue. There's a new model called Painful. Do you like that? Painful. Brian Horrigan developed it, and again, that might be something that you, when you read that, find it of use. There's an application of that. Slide 15 just gives you a summary that you might take on board for problem-solving steps about taking those initial instructions. This is heavily linked to your client interview, to be able to identify the problem. You will then go on an investigation of facts, as we do as lawyers. You will need to identify issues and, importantly, consider the client's goal. Now, those 5 steps will be part of the initial interview with the client, but it will probably become more interviews following the initial one before you can then get to number 6, which is advising the client. You need to put a lot of work into having an outcome to be able to discuss with the client. And then, of course, that's decision making. It is the client's matter, remember. It's arming them with the information appropriate for them to make an informed decision. and then planning and implementing the outcome. Dispute resolution and problem solving really go hand in hand, and it's interesting. I like the comment by Paul Brest that those who are engaged in dispute resolutions should shed adversarial clothing, think outside the litigation box, embrace creativity, create value, and move into the 21st century as problem solvers rather than as gladiators. And having been a litigator for a long time and now solely focusing on dispute resolution processes, it is a very different mindset. And when you are involved in a litigious matter and how you structure and prepare a matter, it is a real paradigm shift that is required to engage in negotiation that is interest-based, and we'll deal with that in the negotiation lecture. Another problem-solving model is a collaborative one, and this is very much linked in with the interest-based negotiation method or approach that we'll talk about in lecture 4. And that's something that you may well find useful for your negotiation practical scenario. So actually, when you are involved in that negotiation scenario, make sure you have listened to, considered and reflected on the negotiation lectures, that you will consider and discuss within your group what problem-solving principle might assist you in this matter. Maybe it is the collaborative one, focusing on the interests and needs of the parties. And how can the various problem-solving models be in fact used? There's really no rigid approach. There is a degree of flexibility that is required, and you need to have armed knowledge of various tools that you can then use for the best outcome for your client. One thing that I would encourage all of you to do is don't stop learning once you leave university and you get admitted as a legal practitioner. ADR, I think, is going to be the way to go for all of you. When I first went into practice, ADR was not really around. We were adversarial gladiators, if you might want to term it that way. But the court system just is now overworked and stretched to its limit, and the court system recognises that they greatly need the assistance of dispute resolution processes. But put that to one side, the court's needs. It's the impact on the parties, whether they be an individual or businesses, as to what occurs in the litigation process. It takes an enormous amount of time as well as energy and impacts in many ways, least of which is financial. So you become aware of the availability of the various dispute resolution options. Mediation is certainly one, collaborative practice is another. In many areas of law, arbitration is used as an alternate to going down the court system, although the way of arbitration is in fact resembling a court adversarial process. But it may well be that even without prejudice discussions, which are very common amongst lawyers, will have greater prevalence. So some tips for problem solving. For you as you're coming into the legal profession, make sure you have an awareness of the non-legal aspects for clients, and they do exist. Develop a sensitivity of issues and have an understanding of the ethical obligations that you have, both under your professional responsibility and going back to the type of professional that you want to be. In the negotiation practical scenario that you will engage in on the 5th of January, and then your client interview, just keep coming back to this slide, thinking about how can I be an effective communicator? How am I able to embrace and use problem-solving skills? What is it that I need to think about with questioning techniques? How can I expand my skill base to obtain more information? It is the client's problem. It's important to work with the client and to have the client as the focus, but importantly, above all, engage in that active listening, listening to the client, what they're saying, what they're not saying, whether it's themselves or through their solicitor, and be able to embrace and work with that scenario. So negotiation, all about understanding interests. The client interview is not about giving legal advice, and so those 2 points I think really do resonate as to what we've been talking about in these 3 lectures, 3 modules of lecture 2. First of all, about building relationships with clients, developing rapport and gathering facts, all about being an effective communicator. And then secondly, an appreciation of the legal issue, knowing what your client wants to achieve and working with them to be able to problem solve for the client. That really is a summation of effective communication and problem solving and the practical application to you in your learning. Finally, I'm the bearer of bad news. It's no longer about you. It is actually all about the client. Just keep focused on communication and remember that these are skills for you to use and apply, whether as a legal practitioner or in another profession that you enter. And that's the end of lecture 2. Thank you.